Hello, I'm Stuart Watson with Oregon Divorce Guides, and I will be walking us through the 11 points of the Agreement to Mediate form for the purpose of clarifying our process and how it works. It might be helpful to print out the form so that you can follow along, or you can take a look at it after the video. I also invite you to pause the video when questions come up so that you can write them down and bring those to our in-person free consultation. The first section of the Agreement to Mediate is the Confidentiality section. Number 1, all discussions that happen during mediation are confidential. As your mediator, I cannot be required to testify in court, disclose any written records, or share any information about the content of a mediation session. This is protected by Oregon state statute. Number 2, when I meet with you separately, as I will for 10 to 15 minutes during our free consultation, what we talk about is also confidential, meaning I won't share that with the other person unless you ask me to. Number 3, what's not considered confidential is the written divorce settlement agreement. Once you've had time to go back and forth refining it, and it reads as you'd like, each of you sign it and date it. This agreement is what is then filed with the courts and becomes your legal divorce settlement agreement. In other words, everything's confidential until it's written down on paper and you've signed it and dated it. Number 4 is a conversation about your expectations of confidentiality with each other. Each of you might have professionals with whom you have a privileged relationship, doctors, attorneys, counselors, and they're required to keep things confidential. As well, each of you might have friends or family that at this point could serve as a great sounding board. Maybe it's somebody who's been through divorce before and you'd like to bounce some ideas off of. The question I have is, do you have any concerns about who the other person may be speaking to in terms of what's discussed in mediation? If you do, we can explore who each of you predict you will be speaking with. You might agree that the other person can speak to specific people and will write their names onto the form and have an understanding that information will be shared in a respectful and non-disparaging manner. This next section covers process guidelines and a little more information about how it actually works at the table. Number 5, you agree to listen and try to understand the other person's goals and concerns. This really refers to the conflict resolution process that's used. While there are multiple decisions that you need to make, and most of them will just clip through rather quickly, for the topics that there's some emotional charge or you have a really different opinion about how it should look, what we do is slow the conversation down and make sure first that you're understanding each other's goals and concerns. Once that's in place, we can begin to explore some options that are going to meet both of your needs. Number 6, you agree to search for fair and workable plans. In this context, fairness has 3 elements: subjective, legal, and practical. Your subjective sense of fairness might be considering the history of your marriage, your different parenting roles, your current and future income potential, what feels fair for anything you're discussing. By legal sense of fairness, we're referring to what might happen if you had attorneys litigating this or you ended up in court. This is an indicator of what Oregon family law considers as fair, in other words, what society currently considers as fair, which may be different from your own subjective sense of fairness. And lastly, we look at practicality. We need to make sure that anything that you're discussing is going to be workable and sustainable for your lives moving forward. Number 7, you agree to provide complete, accurate information for everything that's being discussed. This specifically refers to all of the financial statements, tax documents, and that essentially all the information is on the table to make the best decisions for your family. In addition to this, you ultimately sign a clause in the agreement stating that you have provided each other with the complete financial information. Number 8 refers to our fees. Unlike many divorce professionals, we don't charge for the occasional phone call or email. With us, you are only charged for the time that we actually spend in meetings, which you'll pay at the end of each meeting, and the time that we spend working on written agreements, which you'll pay within 30 days of receiving the written work. The last section is a little more about the mediator's role. Number 9, you're participating voluntarily in the mediation process, and therefore cannot hold the mediator liable for the outcome of any agreements that you might reach in the process. In other words, let's say a couple years from now you're talking to somebody who got a much different divorce settlement than you did. You couldn't come back and sue me for the agreements that you made. My job is to make sure that you're not rushing into agreements, you are taking your time and getting all the advice you need to feel confident in your decisions, and that you're not making them out of anger or guilt. Number 10, while I can provide you with options to consider, I won't tell you what's right or what you should do or what's best for your family. Only the two of you can know that. If it felt like I was biased in any way towards either one of you or biased towards a certain outcome, I'd want you to let me know. It's never happened, but I suppose it's possible. As your mediator, I don't represent either one of you, and I'm not acting as an attorney. I can provide you with legal information, in other words, copies of the law, and tell you generally how it works with Oregon family law, but I cannot predict for you that if you went to court, what a judge would say in your case. Number 11 is just affirming your understanding that you can consult with an attorney at any time in the process. About 25% of our clients find this helpful, and that's usually around the topics of spousal support, maybe a family inheritance, self-owned business, and occasionally somebody likes to take the final written agreement and put it before an attorney's eyes before signing it. We can take some of the wording suggestions that the attorney gives and work that into the agreement if you like. I know this is a lot of information. Thank you for sticking with me through it, and I look forward to your questions and our free consultation.